right, thank you for that introduction. Good afternoon, everybody. My name is Eric Boughman. I am an attorney with the law firm of Forster Boughman here in Central Florida. Sitting next to me is my partner, Gary Forster. And Gary is is an expert in the area of asset protection, and we are happy today to be bringing you this presentation on behalf of MBI titled Protecting Assets with Single Member LLCs. I want to say thank you to MBI for hosting this, and wanted to mention this now and throughout the seminar. We'll repeat this, that if you have any questions, we welcome those either during the presentation or after, or if there's any questions, anything that you think of after the fact and you want to reach out to us, please feel free to do so. With that, we're going to take a look at our agenda for today, and we are going to be discussing single-member LLCs and as a liability shield, its strengths and weaknesses. Probably not the best mechanisms for asset protection, but certainly effective for liability. We'll talk about creditor remedies, structuring the single-member LLC for asset protection purposes, real estate and estate planning strategies, and preserving the liability shield. We'll give you some tips for your clients, and we will have a little bit of time to touch on maybe some tax issues and some issues at the end of the seminar. Most of this seminar is going to deal with the legal issues of liability and asset protection, which is what we understand that you are here for. So to understand how the single-member limited liability company works with respect to insulation from liability and also for asset protection, it's useful to have a little bit of history on legal entities generally. And I like this, where I like to turn things over to Gary and let him give a little bit of background so you understand this a little bit more.
Sure. Nice. Thanks so much for attending. Business entities have evolved really mostly recently. For a few hundred years, we principally used corporations and partnerships. Corporations basically offer what's known as inside liability protection. The idea is that this entity, this person, this legal person, is created to operate a business, and based upon the filing of articles of incorporation, that entity takes on all the liabilities and responsibilities of the business. What's so attractive about the inside liability protection is that only the corporation's assets are subject to the liabilities and responsibilities of the business. One thing we'll discuss today is how over the years there have been some exceptions to that rule, where a corporation is operating, but somehow a business creditor or someone owed money by, otherwise owed money by the corporation, reaches out to the owners of the corporation. It's called piercing the corporate veil. And that idea of piercing the corporate veil is very key to understanding both some of the benefits and the weaknesses of the single-member LLC. The problem with the corporation in general is that it does not offer what's known as outside asset protection. So the corresponding entity to the corporation is the partnership. That exists for years. Many states really operated partnership law without a statute. Partnership is like a handshake. You can have a partnership agreement, but it's an arrangement, a business arrangement between individuals or entities where you don't file these articles of incorporation. And the advantage of that, it's very minor, the advantage, to be honest with you, in general or today, but the initial advantage of that was that if a partner is sued on a matter unrelated to the business, that plaintiff can't come in and take the equity of that partner and take over the voting rights of the partner, thereby kind of compromising the other partner, right? So in corporations, you don't have this outside protection where someone could come in and take the stock of a corporate shareholder It's completely exposed. Whereas in partnership, it's not. In partnership, that claim is limited to known as the charging order. It's a lien on the equity. So the partner in trouble, the partner being sued, continues to vote their interest, but is subject to this lien, whereas the other partner who's uninvolved is pretty much unaffected. The problem with a partnership is that you enter in the handshake agreement with a partner, and you're both totally liable for what happens inside the partnership business. So that's whereas the corporation offers inside protection, where the owners are not liable for what happens in the business, but the corporate stock is totally exposed to outside claims against the owners, the shareholders. The partnership is kind of the opposite, where everything that happens in the partnership, the owners are completely liable for. But if a partner is sued on an outside matter, that plaintiff cannot get in and vote and take over the equity of the defendant partner. But that's kind of the whole 200-year history pre-LLCs in a nutshell. I usually tell people, now you know what I know, until we get to the next slide.
All right. Well, and besides some of these cases, great background, and we'll see some of this come up in some of the slides. By the way, you'll see the case there, Sargent, that's cited in the slides. If you want any of the case citations, these will generally be in the written materials that are also accompanying your presentation materials today. That Sargent case, that's a Florida case, and actually it's been recently called into question on another issue. But in Sargent, that case shows an example of where a trial court had granted a motion initially to turn over stock certificates. So that shows the difference between the corporation and the LLC generally, where the stock certificates were subject to foreclosure. Sargent ultimately presented some other barriers because the stock certificates were outside of the jurisdiction. Well, the case is going on, but another recent case has called into question the Sargent from a jurisdictional perspective. But turning over the stock certificates, that example is in that Sargent case. We also see some of the advantages when we talk about the charging order. We see some listed here. Again, as I think Gary mentioned, the charging order prevents the seizure of corporate stock. You can only get a lien on distributions of the ownership interest. You can't come in and take ownership. You can't control management or affect the internal affairs of the company, other than to sit back and wait for any distributions if and when.
And most charging liens are like a typical, for instance, UCC lien, where you can foreclose it. It's just a lien, the right to distributions if and when made. When lawyers or whoever's talking to somebody is more advantageous than the corporation, the idea is that the LLC has the inside asset protection like the corporation. The business you do with an LLC stays in the LLC. What the LLC operations generate in terms of exposures really stay inside the LLC. But the LLC, why it's preferred to the corporation is it also offers this outside asset protection, this charging lien. So it's kind of confusing because you're talking about a lien as a protection. It's not that the lien is a protection, it's that the rights of a plaintiff suing an owner, suing a member, are limited to a lien. It's a limitation to a lien. That's the protection.
And of course, if you're talking about a closely held limited liability company, where the members are also controlling management and controlling the affairs of the company, typically in those situations, that company is going to, as much as possible, avoid making distributions so as to avoid paying anything towards the lien on those distributions. You could distinguish that from a trust, where you might have a spendthrift provision that allows the trustee to make payments directly for the benefit of the beneficiaries and bypass creditors. With the LLC, if the money comes out in a distribution, it has to go to the creditor first, so you just typically try to set up a situation where the money doesn't come out. Note that the statutes with respect to these protections for LLCs, limiting the remedy to a charging order, are not, they're not uniform across states. Not all states make the charging order the exclusive remedy. There is an exception, including in our state of Florida and in some other jurisdictions, where a single member LLC is subject to the same foreclosure process as a corporate ownership.
Right.
So that presents a challenge specifically with respect to single member LLCs. And we'll talk about some other issues that you can other ways that you can work around that. For instance, trying to work within a jurisdiction that limits the remedy of single member LLCs, just like a multi-member LLC, to only a charging order. Delaware, Nevada, and some other states do that, and maybe some other workarounds to add protection.
So you should keep in the back of your mind the idea that in some states the single member LLC is completely disfavored, so it's almost treated like a corporation. If the owners sue, they could take the business. In other states, it's basically made clear that the single member LLC is given just as much protection as the multi-member LLC, and then in other states, nothing's mentioned. So you want to move toward that protective status, which makes it almost like an international matter, where we're trying to choose a jurisdiction, a governing law that's most favorable when we start a matter.
Now, here's a question that's come up, and I don't know if we have any definitive answer, although I think there's a recognized consensus, or almost a consensus, on what the answer would be when you work through the question logically. But does a charging order create tax liability for a creditor? And the rationale being that in a flow-through situation for tax, you may have a situation where you don't receive any distribution, where cash isn't distributed outside the company, but you still get a K-1, and you still have tax liability if the company has a flow-through tax, so that it flows through the individuals.
If you're defending a member who's become subject to a charging order, and basically what happens is there has been litigation's taken forever. Eric could tell you how long this takes. It takes forever, any kind of even small claims. And then at the end of the road, in terms of the trial or settlement, you get to a collection phase. And then in the collection phase, you take a look at what the defendant, now the debtor, has in terms of personal assets, and okay, we found one, and it's a single member LLC. Well, can we take it? That question has come up a number of times, and I think only a handful of courts have even addressed the issue. Just literally 3 or 4 courts have even addressed the issue, and we're going to get into some of those cases. But one of the factors that Eric mentioned is, well, okay, you've got a charging order. We had a profitable year, and we're going to send you a K-1. And the plaintiff says, whoa, I don't own anything. I just have a lien. Well, no, you have a lien. Any income that comes out, you have the right to. So we're going to equate that to you having the tax liability and not the defendant. The IRS hasn't entirely ruled on it, but the suggestion that the IRS has made, and of course Congress hasn't ruled on it, hasn't created a law on it, but is that this plaintiff has not really acquired equity and has done all they can to kind of win collection on a judgment, but doesn't have the right to collect. In other words, the plaintiff does not have the right to force a distribution. So the suggestion by the IRS is that it's not taxable. But that doesn't mean that the litigation maniacs are not going to take a position advocating that, hey, we're going to send you a K-1. And, unless they've hired someone like Eric or myself to really analyze the situation, it can be a very daunting prospect to get a K-1, to have a matching number with the IRS for, $100,000 worth of tax. So it is a factor. It's a very good point.
Yeah. And I tend to think that the correct answer would be that even if a payment went to the creditor, that the member would still be taxed because it's really a member benefit and you're just paying a debt
Paying
to the
off
creditor.
the debt, yeah.
But there are people will take the other approach, and it's a litigation strategy, and you just need to be aware of it. So we discussed that issue. Let's talk about. I think you talked a little bit about. You gave some background on the partnerships and different types of partnerships. We kind of do a little bit of a rundown of those. We don't need to rehash those. Partnerships present. Yeah, that's where the idea of the charging order comes from initially. And what I think is important to understand with partnerships, where it becomes important on some of the arguments that come up later with LLCs, is that in a traditional partnership arrangement or in a limited partnership, the idea was not to punish the innocent partner. Two people go into business together, one of them has a debt, and a creditor comes along and says, I want to seize your interest. Well, if it's, for instance, at a law firm and you're partnered up with somebody else, now all of a sudden this creditor becomes your partner in a law firm. So the idea was to protect the innocent partner and not make them take on partners in a business that they didn't originally intend, so you could only get a lien on distributions. In the corporation context, you're just talking about a shareholder interest, and then the LLC was sort of a combination of the two, where we still use that partnership.
Yeah, and
protection.
before we had LLCs in the early 90s, late 80s, the law was moving toward the idea of this, what's the word, it's like the cars that are going from gas to electric, the conversion. I can't remember the word. It's like
A transition?
It's like a transition, but there's a word anyway. It's were these LLPs and LLPs. This L, they put an LL at the beginning of partnership and LL at the beginning of limited partnership. What that did, so where we had mentioned that the owners, the partners, are liable for what happens in the business. This LL, limited liability partnership, limited liability, limited partnership, it kind of eliminated. You had to file a certificate, and you'd put LL on the beginning, in the beginning of your partnership, and then that would eliminate the owner liability. So you'd have the duality. You'd have no owner liability on business operations, and you'd have no ability to take equity. You'd have that charging order protection. But those kind of morphed into the LLC. And they morphed beyond even morphing. The LLC just was used after these LLPs were created, so they kind of got left behind.
And I think that what's important or the takeaway from the partnership is to understand later how the single member LLC ends up getting pierced and how we end up with this distinction between a single member LLC and a multi-member LLC, because it comes back to an argument based on the innocent partner rationale, and we'll see that later in the materials. Okay, so we move in after doing our background into the discussion on limited liability companies generally, and what we've talked about, protecting the inside limited liabilities like a corporation, and protecting the equity like a partnership, and limiting the creditor's ability to exercise any type of control or management or any rights other than just sitting back and waiting to get paid if and when distributions are made. But you should still understand that although the procedural and paperwork requirements for LLCs are generally less than a corporation, oftentimes there's no requirement for annual meetings and minutes and so forth. It's still a good idea to do that stuff, because the LLC is still going to be subject to your traditional veil piercing. Anybody who's ever been involved in a situation with corporate veil piercing may know that the way that you attack the shield of corporate liability insulation is to essentially argue that the corporation and the individual are one and the same. They're alter egos, and that comes from the fact that the corporate formalities have not been followed and the corporate form has not been honored.
And it's interesting, we have this Green Hunter case on here. Wyoming was one of the initial, I think we even mentioned it again in the program. Wyoming was one of the initial LLC jurisdictions. I think it was the first one, actually, and had a really nice statute until we had a case with a conglomerate. It wasn't really an asset protection case, and one of the subsidiaries in the conglomerate was involved in litigation, and the court allowed the plaintiff to pierce the veil up to the holding. Well, you never want the veil pierced up to the holding company, you can imagine, because the holding company's got all these subsidiaries, and once you pierce the veil up to the you can get whatever you want. So usually it's very, very difficult to do. And it was like a sucking sound in terms of, like, everyone stopped using Wyoming. I mean, it's unbelievable.
We're still selling them on the internet.
Yeah, well, on the internet you probably can get duped into doing that. But that case really kind of compromised, the idea of using Wyoming. One question we get a lot is, should I use a corporation? Under what circumstances should I really bother with utilizing the standard corporation? And the reality is, it's very uncommon to need a corporation today, even in traditional corporate format, manufacturing, standard type business, where you think, okay, I need a corporation, or I want to use a Delaware corporation. We get this all the time. I'm going to use a Delaware corporation. Really, there's no advantage to doing that. Some of the corporations that go public, it becomes a little cumbersome sometimes to use an LLC or a partnership to go public, because the securities rules were really written for corporate stock. Obviously, that's a total rarity in relationship to the number of entities that are formed. And finally, a few years ago, more LLCs than corporations were formed. But I would definitely go with the LLC based on the inside and outside asset protection.
It almost always seems like the better option, especially for smaller businesses. Again, if you're not going to be publicly traded.
Oh, yeah.
Here's just a rundown on some initial considerations for creating the LLC. The advantages, ease and flexibility. The corporation, or the LLC rather, really offers the best aspects and the best features of the corporation and of the partnership, and it makes it an easy entity for smaller business owners to control and operate. You can also choose
Excuse
your
me, gentlemen.
tax situation. Yes, sir.
I have a verification code. The verification code is G as in golf. I repeat, verification code G as in golf. Back to you guys. Thank you.
Thank you, Harley.
Sure. One thing, you mentioned flexibility, Eric. One thing that is a little tricky with the LLC is that when the statutes created all these flexibilities, actually I was involved in one of the statutes, and it was a question in some regard, because whereas with corporations you have bylaws, you can create a shareholders agreement, which is often fairly limited, and the statutes are very clear with the voting, your annuals, etc. With an LLC, you kind of create your own, and
It could be not everyone create any.
Yeah, not everyone really to create their own corporate operational rules, or buyouts, or control issues, or voting parameters. We had some interesting cases over the year. One case that comes to mind was, we had an individual who operated a large business, let's call it a manufacturing business, to protect the guilty, and very successful, had a salesperson employee, very valuable salesperson, but an employee. And what happened was, the salesperson was doing so well that the founder decided, you know what, I want to bring this person on as a partner, and we're just going to go ahead and draft our own operating agreement. And what happened, it was years before we were involved. What happened was, there was a shared control issue in the operating agreement. If you could get through the operating agreement, I think at the end of it, it didn't really read that clearly. They kind of shared control and benefit of this big business, which it almost seems impossible that that was the intention. So you go to chapter 2. Now you have a separation where the younger owner decides, I'm going to go ahead and take out all the value, all the client lists, intellectual property, software, whatever I want, and pull it into an entity that I own, right? And you think, just seeing that, hearing that scenario, well, I mean, that seems crazy. I mean, how could he do that? What was frightening was that because of the way the operating agreement was drafted, not only could he do it, at least there was a very strong argument that he could pull assets out or share them. You know what I'm saying? Leave them there, but actually copy them into the new entity, because there was, of course, no covenant not to compete written into the document. But that he retained ownership and half control of the old entity. It was absolutely incredible, the whole litigation. But you have to be very careful with this LLC, because although it's flexible, you've got to get it right when you draft it.
It's amazing how often I've seen clients come in that have an LLC that they created themselves, or they used an online service, and you ask them what the ownership interest is, and they don't know.
They don't know.
And they don't
It's amazing.
And you can look to tax records. That's my fallback is, okay, well, what
You
did
mean they don't know, and you
year?
don't know.
Nobody knows. And you try to, and I had one case where an employee, similar to what Gary described, an employee claimed that he was the owner of the company. We sued him for embezzlement, and he claimed he owned the company.
Mm-hmm.
And our
They had no
client
records.
had no real records to dispute that, other than the fact that he'd reported on his taxes, but he couldn't prove that in the past year he hadn't transferred any interest. We've seen that, but in that case that Gary was referring to, if I think about the same one, that was a few years ago.
Yeah.
One of the issues there on the control is that the founder did make the ownership 51-49. So we brought the guy and made
But
it
not the control.
51-49, and as a member, it was a member. It didn't specify whether it was a member managed company. So there was a 51-49 membership interest, but the operating agreement called for voting to be according to the members, not the membership.
Like the number of members, yeah.
And so the argument that I thought was a great argument that the minority partner's attorney made was that the voting on control is equal, because they each are members. So each member has one vote. It's not according to the membership interest, 51-49.
And there's no way the client thought that.
No, they
no
just
way
never
to
thought
thought
about
it.
it. I don't think the client thought anything. I think the client said, go find an operating agreement on the internet and let's sign it.
It's dangerous. It's for
it was
real.
very
We're joking
dangerous.
around, but it was a real case.
So that's the issue. Gary points out a great issue is that without documentation requirements, documentation is often overlooked. So if you are going to document, hopefully you do, and when you're going to create it, where do you form it? By the way, we're on slide 9 of 43, so probably your home state is the best place generally. But when you're in a single in a jurisdiction allows for closure of the single member LLC, then oftentimes we may look to another
Right.
jurisdiction.
So the home state, what Eric's saying is probably going to be respected in litigation. The protections in the home state. The problem is if you're in a home state that's terrible, or has a terribly drafted LLC, you really should look for a more protective state statute. And what are we going to get into? The internal affairs doctrine, right?
And that's one of the issues that comes up is does the, especially with respect to third-party creditors. So what Gary's referred to, we may see some cases that give this example. If you form an LLC, let's say we're in Florida, we form an LLC, a single-member LLC, and we use Delaware. So client has a single-member LLC formed in Delaware, but has an issue in Florida with a Florida creditor, and it sues in Florida court. Will Florida court apply Florida law or Delaware law? Well, Florida law or Delaware law. What we know is that if it's a Florida LLC, the court's going to apply Florida law. If it's a Delaware LLC, at least maybe you have an argument.
Right.
And that's been about, we'll see some cases, it's been about a 50-50 argument. but generally, the operations of the LLC and the statute governing the operation of the LLC is when you're not talking about third-party creditors. When you're talking about everybody who agrees, all the members, or in a single-member case, they're all going to be governed by the state of formation. So wherever you form it, and reporting information will be according to the state and so forth.
Well, the idea is that, for instance, Florida, we're in Florida, adopted the internal affairs doctrine, which means that Florida says we will respect the internal affairs statute of Delaware. We use a lot of Delaware and Nevada. And so, unfortunately, we don't know exactly what that means. So,
we have a disagreement on it.
No, I don't think we know.
It's a guess.
It's a guess because of the statutes. It's not that clear. So we'd love to have a statute that says, okay, if we use Delaware, right, then the charging order language in the Delaware LLC statute will apply to our operation. But we can't rely on that. We can't rely. If we're here in Florida and the business is in Florida and everyone's in Florida and my cousin's in Florida and he works there too, how are we related to Delaware? The litigation people are always attack that because you don't have any connection to the jurisdiction of formation.
And a creditor seeking a charging order or seeking foreclosure did not agree to that. If your members, if the members and managers and everybody else agrees to it, even if you have, for instance, if you provide a financial institution with a copy of the operating agreement and they know that it's a Delaware entity, perhaps they're subject to it. But if your member owner goes out and runs down a crowd of people in his automobile, and I've been injured and I'm trying to collect, and all you have is your LLC interest, well, I'm just an innocent third party. I'm not subject to Delaware.
You weren't doing business with the entity, and you weren't deemed to know that they're in Delaware doing business in Florida. Exactly.
So I think that's a different situation.
It's a different situation. I agree with that. Well, actually, we're going to show you that the courts agree with that.
They have, and it's gone both ways. Here's just some jurisdictional information. You can look and see. And what we recommend is you should definitely be familiar, if you're forming these, with your own statutes and any other statutes that you're going to come in contact with. Again, some are more favorable than others with respect specifically to the single-member LLC remedies and limitations. Choice of law issues. This is the big issue we've been talking about. Is it the internal affairs and the entity's state of formation and the local statutes to that state and the operating agreement that control, or how much will be controlled by something else like the state of domicile? If the company is a Delaware LLC doing business in Florida, will Florida control? And if there's third parties?
Here are your cases.
Yeah, here's a couple examples, and on both sides of this. So this choice of law question, you want me to do the rundown, or
whatever you like?
I'll give you a little background. Wells Fargo v. Barber. This case is a few years old. Miss Barber owned, I believe it was storage units.
Real estate.
Yeah, she owned some real estate, and there was a foreclosure and a deficiency judgment. And Florida has this language in the LLC statute that says that the remedy against an LLC interest is limited to a charging order, except for single-member LLCs. And in the case of a single-member LLC, if the creditor can show that there's no reasonable likelihood of being paid on the charging order interest, the creditor can foreclose. Well, I think the deficiency was $61 or $67 million.
$64 million, yeah.
60, yes, so in millions. And so the creditor didn't have a hard time showing that. And Miss Barber had an LLC. Was this the Nevis one?
Yeah.
The Nevis LLC, and had a Nevis LLC. Nevis, Gary helped write the statute. Nevis.
I did not handle that case though. I think we know who did.
Yeah. So the Nevis LLC protects the single member against foreclosure, but in that case, what the court ended up saying was, as long as Miss Barber is here in my courtroom, her LLC interest, which was not certificated, it wasn't, no documentation, just an LLC interest, uncertificated, meaning there was no certificates. That interest was an intangible interest that was personal property that was resided with Miss Barber, who was in the courtroom in Florida. And because of that, the court used Florida law to exercise jurisdiction control.
I think they got that one. I'm not saying the outcome was wrong. I think they got that one wrong because she defaulted on the debt and then got scared and owned a homestead, sold the homestead, which was completely nuts because they wouldn't have been able actually to take the homestead in Florida. And then started to move things around, right? And so she moved things into a Nevis LLC, which is a very protective entity, but it is subject to the Fraudulent Transfer Act. Now, did Wells act within the Nevis Fraudulent Transfer Act? 1 year? I don't think they did, actually. But instead of saying, okay, your Nevis LLC is a Florida LLC, which I don't get. I still don't get that. Someone's going to have to explain that to me one day. I'll add it to the next book. They could have just said, unless I'm reading it wrong, they could have just said, okay, look, everything you did to avoid the creditor. But we're just going to unwind it under the Florida Fraudulent Transfer Act. Of course, she kept all her assets in Florida, which was so tempting to the court that, I mean, there was no way she was ever going to win that case. But I don't think I call it a Nevis nickel a Florida nickel. I think it's more like it's a fraudulent transfer claim, and she made a fraudulent transfer, which is the transfer to a protected entity with the intent to avoid a creditor. I don't think that's going to be real tough to prove in this case when she owes $64 million. And that's the answer to that case.
Yeah. That's a great point. Miss Barber engaged in what appears from the court discussion to be pure fraudulent transfers to avoid the debt, and so there was a lot of ways the court could have gone.
Yeah.
And this just represents one of those examples of, figure out what remedy you're looking for, and then give the court an avenue to get there. And this was the avenue.
I thought they had the avenue with the fraudulent transfer.
They did. They could have done it another way, but it didn't matter. The court was going to get there anyway. In my view, that was
absolutely, especially with all the money in Miami and Orlando, that she kept all the assets in Miami and Orlando. It's good to understand for the listeners. If you're planning, you can only plan on a sunny day.
This McClure case, this was out of Colorado, and the patient is in the materials. And this is just a case that rejected the Wells Fargo approach. And so we give you one case where the court used local law to get to the single member LLC interest, and we give you another case where the court said, no, the company was formed, I think, in that one. There was
Colorado.
Yeah, but in Arizona.
This is very insightful. Right. Insightful. In some ways, well, it wasn't as clear a fraudulent. First of all, it was not as clear a fraudulent transfer. So it wasn't really a bad actor case. You'll find in these bad actor cases, the court's going to do what they need to do to get to the assets. But it's almost like Sabrina Barber was trying. The collection was against Sabrina Barber in Nevis. Okay, so what happened against McClure was he owned real estate in Arizona. He lost the suit was also in Arizona. Interestingly enough, the assets and suit, I believe, if I recall it right, were in Arizona. It was about 6 years ago, the case. And this is why we use Eric Boughman for this type of litigation. You'll see time and time again in these cases, if you study them, that the people that win them use attorneys seasoned both on the litigation and the planning side. So what happened in this case was the defense attorney had the case removed to Colorado. So here's the key. The Colorado court is looking at what? The Colorado statute. When the Colorado court looks at the Colorado statute and the Colorado cases and the Colorado people and the Colorado jury, they have no problem. We've actually had a couple of these in Nevada. They've got no problem going back to the statute that protects the interest. No problem, because they're in Colorado. It's a Colorado LLC. They feel completely comfortable with it. And so they did not allow breach of this LLC. And I believe it's because they had the case removed back for collection to Colorado. And Colorado protected their own LLC. I don't think we have the other case. Is it Arroyo? Is it the other case? That's
we don't
a
have that one in here.
case.
There's an Alabama case called Arroyo.
Yeah.
If you shoot me a message if you'd like to look at it, it's a very short case, and the court goes through, and it involves LLC interests in several different jurisdictions.
Right.
That's a good 20-minute discussion, which is probably why.
But here's the key.
Yeah.
The court says, Delaware LLC, we're in Alabama. We won't even look at it. Amazing. Totally different outcome from the Wells Fargo case because it was more of a business type scenario. You didn't have a bad actor that they needed to really punish.
Now here's a
Excuse me,
a
gentlemen.
practice. Sure, absolutely, Harold.
I have a verification code. Verification code at this time is V as in Victor. I repeat, the verification code V as in Victor. Back to you guys.
All right, thank you. So it's a practice pointer for you. We mentioned earlier about the documentation. One of the issues in Barber, again, was the lack of certificates, and the court seized on that and said, well, this is just an intangible interest. And another court in Florida shortly before that, that Sargent case, we cited that in the opening materials, Sargent involved the corporation, but because the corporate shares were represented by the certificates, Sargent, in that case, the defendant argued those certificates are located somewhere else. So if you want to seize those certificates, you have to go to that jurisdiction. I think it was Ohio and somewhere else, and seize the interest
offshore.
there. It was offshore.
Yeah.
And so to go there and seize the interest, and the Florida court in that case agreed and said we don't have jurisdiction to
Right.
control that interest. So it begs the question of whether or not if Miss Barber had certificates, especially if she'd had the interest certificated, even her interest, and she put it in Nevis with maybe a manager in Nevis, if she could have at least made the argument that it's not an intangible interest that's represented by the certificates and they're in Nevis, would that have given an argument?
They
Based on
would
the facts,
have forced into that fraudulent transfer argument most likely. Interestingly, with Sargent, the issue with the courts, you understand the practicality of it, is that there was a plaintiff and a defendant. The plaintiff won. It was a construction litigation, and it was obvious guilt. And the defendant, the question was, because in that case, unlike with Sabrina Barber, where she had substantially all of her assets in Florida, Al-Salah had his assets in Dominican Republic and United Arab Emirates. So it's a little bit heavier decision for the court. So the court at that point has to pull what we call a Lawrence and say, okay, you owe this. You need to bring those certificates back, or just bring the assets that the entity holds back so that they can be collected, or we're going to put you in jail for civil contempt of court. And that's a big play for a court, to put someone in jail for civil liability. And I think it's easier for an appeals court to say, we're just going to go with the old school collection, which means you got your judgment and you can collect it in the jurisdiction where the asset is held, and the certificates are held abroad. Good luck. What do they say? The Monty Python, goodbye and good luck.
Good luck.
Yeah, goodbye and good luck. And that was a lot easier. Now, it's a little onerous, though, for the plaintiff who wins with it's a Pyrrhic, victory. So Eric had mentioned that there's a new case in Florida that suggests, no, we're gonna make you pull those certificates back into Florida, if to pay the judgment.
I wonder if we well, I'll come back to that case. We have time to talk about it, but the new case that came out that does not follow Sargent says what I said about Sargent several years ago, which was that the court got it wrong because they missed the jurisdiction issue. So we'll see if we have time to come back on that one. Moving along in our presentation today, so single-member LLCs, and this is what we touched on early. Our whole seminar is on using single-member LLCs for asset protection. But one thing that Gary will tell you, and foreman needs, and people who do this regularly, is you really want to try to avoid the single member LLC because you want to avoid the risk of foreclosure and reverse veil piercing. And that comes back from the history of the LLC and why there was protection for multi-member LLCs similar to partnerships. It all comes down to that charging order. And the case that undid it all was the bankruptcy court decision in Ray Albright. That was, I think, in 2003 or 2008. It's in the case materials. 2003 bankruptcy court case. And to his credit, Gary and the folks, Gary and I have worked together since 2005, and he was counseling people years ago to be careful of using single-member LLCs because we could see what was coming down the pike with Albright.
And then eventually it hit. That's bankruptcy. Bankruptcy is also very dangerous in general if you want to protect what you have.
Bankruptcy is not a good place to be, and you can see this language from the court. It just basically says, look, this the single-member LLC was not formed to protect other members. And so because you don't have this innocent partner rationale.
Even though that's the same Colorado court, the same Colorado statute that does not say that the single member is exposed. It just says all LLCs are protected. But if they want to get to something, they're going to get to it. In bankruptcy, they're definitely going to get to it.
The bank, we don't. You do one or the other. You do bankruptcy or you asset protection, but it's tough to do both of them because the bankruptcy courts shred this stuff.
And eventually
the judges are appointed for life.
Yeah, and eventually that Albright made its way into the civil courts, and funny enough, it was a Florida Supreme Court decision. Oh, it's on the next slide.
There it is. Olmstead in 2008.
Right.
And this was Florida Supreme Court. It went up to the 11th Federal Circuit on this, on a certified question of whether the remedy against a single-member LLC was limited to only a charging order. And the court got there in a little bit different fashion. They used the innocent partner rationale, but they also said that where there's only one member, there's no other members to object.
Well, they essentially, I don't know if you remember this, I never forget it. They essentially said it's just like a corporation. They said the LLC is very, very similar to a corporation, and what that led to, we had mentioned in the beginning of the presentation that corporate stock can just be taken. That's why we don't use corporate stock. If shareholders sue, they lose the stock. There's no protection over it.
And we had language, I think, in our statute. Oh, sorry. That said that it gave the other members the right to object as well. And so since there was no other members, they could treat it like a corporate interest.
That's right. But it resulted in this idea that it was like a corporation. My point being that it sacrificed the whole prior LLC statute. So they had to go back to the drawing board. And they redrafted the whole LLC statute because it completely destroyed all the protections. But they excluded the single-member LLC. The single-member LLC is very, very, very exposed in Florida. So we try to avoid that at almost all cost.
And I think that Olmstead gave rise to really the new Limited Liability Company Act. It was at 2012 or 2014 under the uniform laws, and then Florida adopted it. Was it?
Well, adopted a form of it. Yeah. It did trigger that. It did trigger that. Yeah, it did help that along. Actually, that's true.
Sorry.
So it's one thing you should think about. In some the case is great actually. In some jurisdictions, I can't emphasize this enough. So you've got, like in Florida, where if you're a single member, you're out. You're out. You're not going to be in good shape if your single membership interest is liened. You could be foreclosed. That's true in other jurisdictions. It's somewhat less clear in other jurisdictions. And then there are the jurisdictions that say, look, the membership interest is only exposed on an exclusive basis to the lien, the charging order. And then some jurisdictions like Delaware and Nevada say, and that includes the single member LLC. And those are the ones, if you're forced into the single member LLC and it's got value, the actual entity and assets in the LLC have value, you have to use it in other jurisdiction.
And keep in mind also that Olmsted involved, it was an FTC case,
Oh,
Federal Trade Commission.
Scammer.
They were going after scammers, credit card fraudsters, and in those cases, it's another one of those circumstances where the court wants to get somewhere, and you get the right case, and you get there.
Oh, yeah.
This is another one. This Kersey case, in a sense,
That's an
here we've
interesting
got,
case, yeah.
now here the debtor has a multi-member LLC and had defaulted
Delaware.
on this big loan, and courts hate this. We've seen a couple cases where there's a settlement, and then the debtor reneges on the settlement, and this was this 99% owned by the debtor, 1% owned by the spouse.
Yeah, which is in itself asinine.
Yeah, you got to give more than just a nominal interest, and again, we've said that. Gary said that for years. We gave opinions to clients 10 years ago. We're not sure that 1% is going to cut it because you're going to run a risk that it's not really going to be a real interest.
It's not real, yeah.
And that's essentially what California did here. Is California found a remedy that reverse veil piercing was permitted because there was no other remedy. Essentially, if you read through the case, you see how the California court gets there on this rationale. That they look at what the requirements are for regular alter ego and veil piercing remedies, and then the court draws analogies and essentially says, when you boil it all down, what the Kersey court says is my takeaway is that you got to have a remedy, and if there's no if we can't foreclose on the interest, then we're going to reverse pierce.
California basically only had a corporate case. And the corporate case said foreclosures, the idea of allowing reverse veil piercing, which is this idea of a plaintiff of an owner can reach the equity of the defendant, doesn't apply to corporations. Because you can just take the equity. You can just take the stock. But that's not really applicable to LLCs. I don't think it took the Corchi case, a Corchi scenario to bring the court to that conclusion. I'm shocked it actually lasted that long. What happened in Corchi was the guy, Baldwin, the defendant, was a huge developer, seemed from the case maybe even a billionaire. And he had this family structure. It was a very involved Andromeda strain type structure where he created the family partnership format and segregated a lot of properties and money, was making outrageous distributions, was distributing almost $100 million came out of this family. And then it looked like he got into a little tiff with a guy with a credit idea, but that's actually kind of common with the state guys. So he had a creditor. He just decided not to pay him. Decided not to pay him $5.5 million. And so, what's the court going to do? It was an obvious debt. The plaintiff comes in and says, look, I got to get paid. Baldwin says, I don't have to pay you. I'm all asset protected. What are you talking about? If you want to get a charging lien, get a charging lien. And the court was not going to let that stand. It just was a bad faith, another bad actor, and the problem with the whole situation was that it really still all looked like Baldwin controlled the whole thing. Baldwin owned 99%. Baldwin had the tiff with the creditor. Baldwin was this. Baldwin was that, and they allowed the veil piercing. The idea is that you at least have to take a shot at looking like you're at least an investment.
And he was making loans to his kids that he was forgiving.
Well, he was making all kinds of distribution, but he decided not to make any more.
They made I forget what they said, $43 million.
A huge amount of money.
Distributions over the prior couple of years until the charging order was entered, and then there were none. And then doing interest-free loans that he kept extending to the kids was really a bad actor case. And then note the court still went to this innocent partner rationale and said, well, in this case, you don't have the innocent partner concern with the multi-member because the partner is the spouse and California is a community property state, and so the spouse will be liable for the debts anyway.
You know, interesting, what we use a lot, I have never seen it tested, is so in California, you've got the community property issue. So the debts of one spouse often are owed by the other spouse. What we do is we say, okay, you've got no tenancy by the entireties option in California, which means spouses own together, and if one spouse is sued, the assets or the entity is not available to the creditor. But when we formed an LLC in Delaware, Delaware does allow for tenancy by the entireties. So why not form it together with the spouse as tenants by the entireties, get that added protection, and look like you actually have a jointly held holding company? You probably don't won the case.
Yeah, I never saw any argument about the internal affairs doctrine, the
No.
fact that this was a Delaware company,
That's true.
and there was a limitation of, that they should have applied Delaware law. So I don't know if that's because the court just heard the argument, didn't care, and didn't put it in the opinion, or if it never was raised.
I think it's because
and that was really that's.
I don't think it was raised.
But it wasn't raised. That's a shame because that was their best argument.
Yeah, but I think it's because this case, the claim was just limited to the issue of whether or not an LLC may be subject to reverse
The appeal issue
Yeah.
was that. The appeal after the court had gone through and all the machinations of what remedies were and were not available. That's what it came down to. Interesting case. And again, the sites in the materials, if you want to read that and look at the case. And then you'll also see in the materials cases that have rejected that approach. Glick is, I believe it's an Illinois case involving a Delaware LLC. And the court just flatly rejected that approach. So two different ways to look at the same issue, essentially, which is the whether the remedy of reverse veil piercing or some other remedy is available to seize the interest of a multi-member LLC. So keep that in mind as you're doing your workarounds for single-member LLCs. If you're going to add a second member, which we all often recommend, you have to put somebody else on there.
We pretty much always recommend.
Don't do 1% for a spouse or a 8-year-old. Was the one person that got upset with us? We said that 1% for the 8-year-old daughter probably was going to create some exposure issues, so the client fired us and went and got somebody that told him that it was fine.
I don't know. We don't know what he did.
I don't know. So, but the client was not happy, and that was just a warning. So creditor remedies. Other than the charging order for the LLC, I'm looking at our time, about an hour. So, the bulk of of really the meat it's talking about the LLC and the particular remedies, but other remedies to be aware of, veil piercing. This again is
It is significant, though, these other remedies, with
Yes.
the single member, especially.
because there's so many analogies to the corporation. There's so often
To
this
being the same.
alter ego,
Yeah.
and that's what it is. It's the adherence to the fiction of the separate existence of the corporate entity as a separate
Can't
person.
blend funds or
If you
share
don't-
checking accounts or any of that.
Yeah, if you don't honor that, you're going to run into problems. So, the single member, meeting minutes, documentation, treating it like a true separate entity,
Separate
rather than
insurance,
individual.
separate lease, separate everything, separate chairs.
Here's several factors for veil piercing. Very similar to a corporation. In fact, some states will have, and we have this in Florida. If I'm in this situation, there is some case law in Florida that's, and I don't know if there's been anything recently, but traditionally we haven't had any veil piercing cases on the LLC, but we do have cases that say two things that are important for us here. If Florida has not addressed an issue, we will generally look to Delaware law as persuasive.
happen.
So we can go to Delaware and pull Delaware cases. And then the second is for LLCs, and Delaware has said this as well, is generally oftentimes for things like veil piercing and other remedies, we will look to the other statutes, look to the corporate statutes, because this is more 15, 20 years ago, but even today the LLC is relatively new compared to other forms, and so we'll look to the corporate remedies and corporate statutes as persuasive when there is no specific law on the LLC. So when you combine those, it essentially brings us to veil piercing being the corporate remedy of veil piercing applying to LLCs.
I do have a verification code, gentlemen.
Great. All right.
Verification code is M as in Mike. I repeat, verification code M as in Mike. Back to you guys.
Thank you, sir. And as we mentioned earlier, when you are engaged in fraudulent transfers, or if you want to come up with some other creative word for it, it might be late stage planning, I think is what I've heard it called.
Yeah, in this case, they're actually pretty criminal.
This was Cutoli as a case we've provided the site. This was like a saga, and this one it provides. The reason I like to include this in the materials is the folks involved they tried to shirk out on their obligations, or the debtor did here, moved from California to Florida, didn't pay, tried to move assets around, and then shot out some emails to an attorney asking about offshore asset protection. And at this point, we're not doing asset protection. We're doing creditor dodging, which is highly discouraged.
Someone's doing it. We're not doing it.
We're not. We are, but this is what these folks, pardon me, this is not what we are engaged in, but that's what these folks are doing here. They're basically just trying to avoid
pretty
paying
blatantly, yeah.
And
they actually found a lawyer, though.
They found a lawyer, and you can find them. I think 2020 found several of them, right? It was 2020, 60 Minutes?
Yes.
ABA?
Yes.
So, several
60
attorneys.
Minutes, yeah.
But here's the scary part of this case is they ended up going into bankruptcy. There were two actors on the debtor side. It was the debtor and the debtor's girlfriend or boyfriend, spouse, significant other. So it wasn't a spouse, but it was a significant other. And when they went into bankruptcy, the bankruptcy court allowed for the turnover of the attorney-client communications. Mm-hmm. And so this is why this is important for our attorneys who are watching today. And there was two justifications, at least two justifications for this. One argument that often will get made in connection with fraudulent transfers is the crime fraud exception, but the counter argument to that is that fraudulent transfer is a statutory remedy. It's an equitable remedy. It's not fraud. It's not the same thing as fraud, and so crime fraud doesn't apply. That argument works sometimes. Sometimes it doesn't.
It's pretty much gone now with the Husky, right?
Well, we've got a Supreme Court case that's kind of called that into question. But there's a couple other factors here. Is the person that filed for bankruptcy protection, the assets of the debtor become under the control of the trustee, and so the trustee said, "Well, I should control."
That's your issue with bankruptcy. You give it up.
Yeah, I control the assets, which includes that communication. But what about the partner, the significant other who did not file for bankruptcy and may not have engaged in any communication? Well, they hired the same lawyer, and the argument that the trustee made, great argument I think, that the trustee made was that under the joint defense doctrine, two defendants can have the same attorney, and they are entitled to all of the communication that occurs regarding that case with all of the defendants that are subject to that joint defense. And so the trustee takes over the communications that they're entitled to from the debtor and is now entitled to all the other communication. And it comes out these emails about, let's move your assets to wherever they were going to try.
Yeah, the lawyer was really bad.
Looked terrible for you don't want to be that lawyer. No, so keep that in mind. You don't want to be
also
on Cutoli.
It's just a general idea. So the bankruptcy idea is to discharge debt, right? So you put everything out there, and they will discharge your indebtedness. You're honest about it, and then there are protections over certain assets that you'll be able to retain. Sometimes that works. Sometimes it works. Usually, though, when there are significant assets, the discharge gets looked at with a little more, with a little stronger lens. And if there's any bad acting, you are going to get battered in bankruptcy because of this fraud exception. It's not just the crime fraud exception to the attorney-client privilege. It's just that if there's, quote, fraud, you will not be able to discharge your debt, and the bankruptcy court can act in a very onerous way, and basically call your entire filing into question. There are potential criminal charges. You could go to jail for even civil contempt. It's very, very dangerous, the bankruptcy situation, unless it's been completely analyzed by both bankruptcy counsel and asset protection counsel.
Yeah, there's a lot of, and that was, I don't know if it's in our materials, but there's a Supreme Court case Gary referred to. It's Husky v. It's a Husky case, came out a couple of years ago. We've cited it in other presentations. U.S. Supreme Court case that can essentially found that in 7-1 decision. It was after, I think, Justice Scalia had passed away, so there were only 8 justices. 7-1 decision that a fraudulent transfer was akin to fraud,
and then you hit the fraud.
The debtor was denied the discharge because of the exception to discharge rules under, I think it's 548 of the
Whereas the reality is, fraudulent transfer is not, misleading someone for financial gain. It's not. It's just not fraud, in my opinion.
Totally different context. Yeah. Another way that another remedy for creditors you need to be aware of, again, we've mentioned it earlier, the alter ego issue, and this is where there exists no separate identity between the member and the LLC. There's a unity of ownership, and if you use an LLC and you either use that to perpetrate a fraud, or you were trying to hide behind the LLC after perpetrating, or what the court thinks has been the perpetration. So, word, a perpetration of fraud.
I like that. Perpetuation.
A perpetuation of fraud, maybe. Then you can run into this issue of alter ego liability, where you and the LLC are treated as one and the same. There's no distinction between the two of you. We cite this Sky Cable case. I would talk about that a little bit more, except that our time is a little short, and I want to make sure we get a couple other things. But you can look at and read this case. But the takeaway here is that the court, this is like the California case we discussed earlier, the Kersey case. Here, this is a fourth. Let me make sure I have I think it's a fourth DCA. It's a federal case. Yeah, Fourth Circuit, Fourth Court of Appeals in the federal courts up in the Northeast, looking at a Delaware company, single-member LLCs, and interpreting Delaware law, which protects the single-member LLC. And here the court says that you're not going to be able to use a single-member LLC and hide behind that to keep your assets from being attached by creditors who have claims against you due to your allegedly fraudulent activities. It's the court using alter ego to do what the statutes won't allow. So the Delaware statute says we're in foreclosure, and now in the one case we had reverse foreclosure. We've got the Fourth Circuit using alter ego. I'm dying. If somebody knows of one, or send it to me. If you say come out, I'll be on the lookout. This case gets cited in Delaware, and how a Delaware court responds to it. If the Delaware court agrees that they reached the right conclusion in Sky Cable, or if a Delaware court says you guys were out to lunch, Delaware totally protects the single-member LLC, period, end of story. But that is a story that hasn't yet been written. Look at this big one here, judicial discretion. Alter ego, I wish I could give you set facts. It's kind of one of those things like you know it when you see it. I like this language in this Turner case. This was another case that we cited in our materials. This involved a doctor who had gotten himself into trouble and had created several, as I recall, entities and used them purely for asset protection. We typically, when Gary works with folks, the folks in our office are dealing with people on creating entities and doing asset protection planning. We like that to combine that with corporate structuring and planning and maybe personal estate planning and combine it all into one package.
For a purpose.
For some type of purpose, this Turner case gives the reason why, and it's that if courts think that you are just engaging in the use of LLCs, especially single-member LLCs, but any type of work that's solely for asset protection purposes, some courts don't like that.
There's a couple courts that don't like that. There is an LLC statute in Delaware that does address it. That does not. That discusses the purposes and says that they apply no matter what the scenario. That the protections apply no matter what the purposes or lack of the purposes, which I like. But you have to be careful with this when you're just creating a business entity for an individual purpose.
Yeah, it often, we're looking at bad actors, often engaging in some type of fraudulent transfer or something close. If you're doing everything on the level and on the up and up and doing it ahead of time, generally it works. You're going to be safe.
Mm-hmm.
So that's a big part of it. Other creditor remedies, reverse veil piercing we talked about earlier. The Sky Cable case that I just mentioned. Whether you consider an alter ego case or a reverse veil piercing case, it gives mechanisms to the courts to go after the LLC interest that you think is otherwise protected. Again, the GLIC rejected that approach. Just some pointers for your practice. If the LLC and the individual are acting as one and the same, then the courts might treat them that way, and all of these protections we talk about will not apply. And Kersey is the example of, in our view, don't be greedy.
Yeah.
This is the guy who's making, make a little distribution and pay the creditor.
Or use it as leverage. Just make a settlement. Like say, look, you're not going to reach my assets. Maybe I didn't set it up right. Maybe I didn't have the right counsel. But it's going to be hard for you. It's going to cost you money to litigate to try to reach my investment assets inside my family LLC. I'll play half, or we come to a conclusion, because that's actually the true benefit of these structures. They're barriers, and you can kind of move on with your life, negotiating something out. When you try to block somebody completely who has a very legitimate claim, the court becomes your enemy.
And I look at them like big speed bumps, depending on how well structured and what your position is. These can be speed bumps. But always keep in mind the bad actor issue. I encourage you, if had that guy distributed $50,000 and paid the creditor, it would have been tough for the creditor to go in and make an argument to foreclose because they'd be getting paid. It's going to take you a long time, but you're getting paid.
Oh, you mean slowly,
just pay a little bit,
and then settle.
I think you pay a little bit, and you make it very frustrating for the other side, but you pay, and in the argument, if you go to court,
you make a general distribution. He gets his little piece,
and that little bit goes,
and then he gets tired of that.
That's right.
That's probably
and then the creditor, after a while, gets tired of it and takes some money.
Mm-hmm.
Jurisdictional arguments. We see this. We saw it with the Sargent case a little bit. We saw it with the Barber case as a jurisdiction argument, choice of law argument, But
what we probably should note, like for instance, Barber used a Nevis LLC. But Eric can tell you, because Eric handles the litigation side. As bad as Barber was, she was running from creditors. She had the Nevis LLC. They said it was a Florida. All her assets were in Florida. What if she had created a Nevis LLC or a Nevis trust years before? Let's say she created even a single member Nevis LLC 3 or 4 years. Let's say 5 years. Okay, she had a note. She owed the debt. She created this entity. She had a lot of money, and she kept the money in a Swiss bank account. It was owned by a Nevis LLC. Better would be a trust. Let's just say Nevis LLC. And she notified the bank. She said, "Bank, I know I owe you $70 million. I just want to let you know that I'm doing some estate planning and some asset protection work, and that I've funded a Nevis LLC." Well, would the court have reacted the same way, number one, on a planning basis? Would they really have minded that she did estate and asset protection planning offshore as part of, like, let's say, an overall estate and asset protection plan, where she put $10 million there or something like that? Probably not. Probably not, because she wasn't reacting to any breach. Her note was being paid on time, etc. Number two, she let the bank know. So 4 years later, there's no fraudulent transfer claim that would likely have expired. And then number three, even if none of that worked, and they were upset because she breached the loan and the court wanted her to pay, the assets are offshore, the entity's offshore, and everything was done in a very seasoned way. She probably would have kept what she had. It's just good to keep the other side in mind too, that we mentioned this whole seminar is on the problems really with the single member LLC and how to avoid them, but that this stuff really can work if you do it in a methodical way.
And we've seen a case similar to that in a different context with trust, with self-settled trust. There's a Delaware case. It relates to Florida and New York, and it's Trustco. I don't remember all the parties, but the Trustco case, that's exactly what the debtor did there, is notified the bank that they were doing some planning and setting up a self-settled trust, and later when the bank came calling and trying to unwind the trust, they were past the statute of limitations and the trust was on.
Yeah, we thought that the court might come up with a wildly detailed ruling explaining how Delaware law works and why it's protective, and we were getting all excited, and the court just said, you know what, they were told 5 years ago, 4 years passed, they're out of luck, over, case over. So it was in some ways better even.
There was no nefarious activity.
Right.
Other creditor remedies, this is, this transfers case is an odd case. It's not very long. You can go read it in Nevada. This is kind of interesting because Nevada has traditionally been very favorable towards asset protection. That arises from some public policy. I'm licensed in Nevada. I started my practice there, and the public policy was to promote asset protection because they were not successful in tort reform in the way that they wanted it in the early 2000s. And so the
doctors,
professionals, the doctors, I mean, they couldn't even get liability insurance. So the doctors are going bare, and they were getting killed. So the court said, well, you're really exposed if you get sued here. You're getting multi-trillion-dollar judgments. But we're going to allow you a lot of leeway to protect your assets in probably the most favorable U.S. state with respect to trust and LLCs. But again, when you're talking about a federal court, if you're talking about an alter ego issue, you never know how a court's going to look at this. And so we've got this Nevada decision. The public policy and choice of law arguments that we raised earlier. We talked about Barber and Huber. This is a case that involved
bankruptcy,
BB&T. That's the BB&T case.
That's the construction bankruptcy case.
Yeah.
Was BB&T?
Oh no, that's right. Huber. Never mind. Yeah, you're right. No, sorry. Yeah, Huber's was a trust. Yeah, that involved the self-settled trust.
Number of creditors. Yeah.
But again, it was a situation where the trust was formed in one jurisdiction, and it was an Alaska trust, and it was enforced in the bankruptcy court in Washington, and the court used Washington law. Again, it just represents another example of where you think you're doing everything right on paper, and then a court just says, well, everybody's down here in Washington, so use Washington law.
Yeah, and also you got to be careful with this idea where people aren't going to get paid and you're in bankruptcy court. We cannot emphasize that enough. You've got all these creditors. You have a bankruptcy trustee who's going to step into the shoes of Huber. Huber has a Alaska trust. He controls the protector, and all in Seattle, or I think it was Seattle, in Washington State, and all the assets are in Washington State. And the bankruptcy court says, we're going to pull the public policy card, which is very hard to do in civil court, but in bankruptcy court they can kind of do whatever. We're going to pull it. It violates public policy for us to respect the Alaska trust, so we're going to give all your assets to the creditors. You got to be very careful with this bankruptcy stuff.
So we have a little bit of time. We have about 12 minutes left, and I want to make sure we have time for questions, of course. I'm going to skip a little bit probably here. Because this is a little bit kind of telling you another way of some of the things we've talked about.
Improper use of the entity. In Florida, you almost have to. have a
Florida and
proper
Delaware,
use.
yeah. If you have veil piercing, you have to show that the entity was used for fraudulent purpose. That's becoming more common in most jurisdictions. So you just can't pierce a corporate veil because you think the corporate formalities weren't followed. You got to show the corporate formalities weren't followed and the entity was used for an improper purpose. And of course, as we've said over and over, and we give you the cases, bad actors get bad results. And that's from the FTC's crackdown on the fraudsters in Olmstead to some of the more recent cases we've discussed, and then whether asset protection in and of itself is a proper purpose. We see cases across the board, but I think if you do asset protection with something or other planning, and you do it in the right time, do it ahead of time, and you're open about it. We've been involved in disputes where we've been an open life. We've handled cases with clients who are being sued. There's insurance claims, and we explain to the other side that that their structure limits their exposure, and the other side says, "Well, okay, prove it to me."
Well, they get upset, and then we just show them in a calm way.
We've given up tax returns.
Oh yeah, absolutely.
We've given up financial. I've had clients do financial affidavits.
Yeah.
And actually give everything ahead of time to explain to the other side why litigation would be futile after a certain level, and that's been a very successful approach. I think folks are,
and in the few cases we've handled, we said, it's a pretty good defense case, or it was our own plan, something like that, where the plaintiffs haven't hired competent counsel who understand asset protection and the selection of jurisdictions, etc. They can go on a while, and what happens is eventually the actual underlying client paying for the collection action eventually just says uncle. And then we come together and we explain everything, and everyone understands. Look, you're just not going to reach these assets.
And that's where sometimes fighting for every dollar can be useful. If the client really is protected and you're really in a good position, you've done everything you need to do ahead of time. It's the opposite of the Kersey case. We had a client a few years ago, a healthcare client, where we fought over, I think it was $1,200 in an account. And the point was just to send a message to the other side that the $1,200 wasn't exposed.
And we won it. We got the $1,200.
Yeah, when a plaintiff's lawyer spends $5,000 and can't get the $1,200, they get a little frustrated, and we settled that case pretty well. So this stuff can be very effective if done properly. And we're going to talk about, in the next few minutes, I want to spend the closing here talking about how to structure your single member LLC in particular for maximum protection. Go ahead. We have another code?
Guys. Yeah, I'm going to give you a code. Next verification code is T as in Tango. I repeat, verification code T as in Tango. Back to you guys.
And entirety ownership of the LLC. If you're tenants by entireties, for those not in a TBE jurisdiction, TBE essentially protects the assets of each individual spouse as marital assets. So you can't, if you have a judgment against husband but not wife, or vice versa, you can't touch marital assets that are properly titled as TBE. The titling can be a little tricky.
Some states are even more tricky.
Yeah.
Some states have TBE for real property. Some states only allow for personal property. Florida is very broad, but also has some silly restrictions for certain types of assets.
Financial accounts.
Bank accounts. They really need to simplify all that, to be perfectly honest with you. But it's very, very powerful.
It's really, TBE is a strong argument. It's for when I'm looking at it, I just want to look at documents. I don't want to rely on a client to tell me that they own something as a marital asset or as a tenants by entirety asset. I want to see the title documents, because so many times they think they own it as a TBE and it's a joint tenants, or it's two names on there.
And just because it says TBE doesn't mean it's TBE either.
That's right.
Qualify as, and you have to qualify through the entireties. If the asset wasn't acquired by the entireties, it's not TBE. Even if you put TBE on it, that's a different seminar. But it should be kept in the back of your mind.
And next way to structure single-member LLCs for asset protection is to avoid the use of the single-member LLC when possible. Gary, Gary, what do you like to do? We got one on here, the trust. How do you avoid that?
Well, it depends on the scenario. I mean, if you have a family type entity, you would use the TBE. You would hold jointly as spouses, and then if the children are minors or young, you would typically form beneficial trust for them, spendthrift trust for them, and they would have more than 2 or 3%. So you'd have tenancy by the entirety as the first line of defense if husband or wife were sued, and then each of the trusts would add the additional member, creating almost assuredly, if you got more than 2 or 3%, a multi-member LLC. What's nice also, that people like about those scenarios is that trust that owns the interest in the LLC, maybe a family LLC, can also be used to benefit the children in other ways. You can fund those trusts with college monies, with whatever you want to do, and though the monies put into trust for the child, if the trust is properly drafted, are not available to a creditor of the child either. So that you created the trust fund baby. That money will be distributed by a trustee for the child's benefit and cannot be reached by creditors of the child.
And as we kind of come to it, I know we didn't hit some of the back end issues, but we hit the big points for you today. And I like the idea of closing out with this, a couple minutes talking about this idea. I came across a case, and Gary and I have talked about this a little bit. If you have a single member LLC, and now you have a claim against the LLC, and you're in a situation where there's potentially a foreclosure on the LLC interest because it's a single member, then you want to add a member. Can you add a member and avoid something like a fraudulent transfer argument? So obviously you can't just give away, you can't just say, okay, my brother's a 10% member of the company. But if you're at risk of losing it and you're involved in litigation and you're subject to a claim, is there a way, for instance, that you could sell? If your company's worth $1 million, can you sell a 5% interest for $50,000 to fund your litigation? That would be one scenario. And so I have this question that we have discussed, and we have in the slides here is, how might you add a new member in response to that, and could it work? And the case, that Sardis case, and the full citation is in your materials, in the written materials. In Sardis, that seems to be what happened. This woman owed Lehman Brothers, I think it was, some money. Or he was a trustee wrapping up Lehman. Obviously, they're not around anymore. And transferred 10% to her son. It seemed to prevent foreclosure of the interest, although the details are a little sketchy from the case. But it gets you thinking about this. And so, as we close out, Gary, what are your thoughts on adding another member and doing it so it doesn't look like a fraudulent transfer?
I think it becomes a technical issue. So depending on the state, every state's got its own Fraudulent Transfer Act, which is its own disaster, in choosing which fraudulent transfer law. There's your year of litigation. And there's a new act which chooses for you, but very few states have adopted that yet. So you go back and say, okay, we think that, let's say, New York's Fraudulent Transfer Act is going to apply, and we try to figure out, okay, it says, I cannot transfer an asset to avoid a creditor. But can my LLC issue 10%?
That's another way to do it, right?
Right. Issue 10% to somebody who, has been looking at my company for a while for consideration. So if my company's worth $10 million and I want to sell 10%, I get a discount. I don't have to sell. It's not worth $1 million. It's worth $600,000. I take in the $600,000. I've got the new owner. Now I've got a multi-member LLC. I think courts are going to then start to focus on, well, you didn't have one when you started. You know what I'm saying? And when you started, the odds were stacked against you, and we're going to leave them that way. And I think that's really the hurdle. I don't think there's a problem in issuing. I don't think that's a fraudulent transfer. I just think that there is a snapshot issue, because you started your case with that issue. But we've done many analysis on similar issues, and a lot of times, because fraudulent transfer unless it's a government claim or something, is not a criminal issue. And there's no penalty to it. There's no penalty to it. You just have to give the money back. Sometimes you do it. Sometimes you do it. Given all the considerations at issue, but
especially I think if
really
you
depends.
it's the idea of don't be too greedy about it. If you're taking that money, you're using it for litigation. If you're using it to pay people, you're not sticking it in your pocket.
You're getting full consideration.
You're getting consideration, and you're using it. Maybe you make partial payments on a debt or another debt if you got multiple creditors, and you're actually using it for a good purpose. And so it's something to think about. With that, I think our time's up, and leave you with this thought that pigs get slaughtered or pigs get fat, and in a vegan or vegetarian household they just stay fat and nice and cuddly. So
it's good to keep in mind.
Good to keep in mind. Thank you very much again to NBI and for all of you today for joining us. Any further questions, please feel free to reach out, and we're happy to address them. Harley, back to you, sir.